Well, good morning, everyone, and welcome to Russell Kennedy's webinar, A Practical Guide to Preventing Debt Recovery and Navigating the Process in Aged Care. My name is Victor Harcourt and I'm a Principal of Russell Kennedy and Head of the Aged Care Practice. My job today to facilitate the panel discussion and to introduce it to all of you. Now, there's quite a few people who have registered to participate in the webinar today, and some are quite strategic in terms of when they seek to join, waiting for these introductory remarks, which are necessary, but perhaps a little bit boring to be completed. So allow me to make my way through them before we actually get to the main game, which is listening to our panelists, ably assisted by others able to answer the question and answer the questions that may be posed. So firstly, just so everybody is aware, all attendees will be on mute and cameras turned off. For those of you who have issues, any technical issues with this webinar, please contact the BD Tech support using the Zoom webinar chat function. If you have any particular questions for our panelists, then please use the Q&A section to make those, ask those questions. And indeed, if you've got any comments on the content of the webinar or anything you wish to share with the participants, please use the Q&A section, and we'll reserve the chat panel just for any technical issues or the like as well. And that way we can manage the process. Now, for all of those participating today, we'd really encourage you to fill out our webinar survey. So following the webinar, we will send through a survey link, and we would ask you to complete that, as we really value your feedback. And we certainly do input into our future planning and presentations. And finally, so that you're aware, we are recording this webinar, so it will be available for you at the conclusion of the webinar and once properly edited, to get rid of all of the bloopers that undoubtedly will occur. Now, just so that you're aware, again, the information contained in this presentation is by way of general commentary only. While we encourage you to ask questions, we ask that those questions be of a general nature. Any questions of a specific nature we're not going to be able to answer, but we would encourage you to get in contact with us later, as we are not going to be providing legal advice during the course of this webinar or in answering the questions. As I say, any specific questions, please ask them of the panelists or us after the seminar. So by way of an introduction, what we're going to cover today is how we pursue debts from deceased estates, how to pursue attorneys who are misusing the funds, debt prevention and mitigation strategies, and debt recovery procedures. And these are certainly really important topics. They're always important, but we anticipate after 29 years of unbroken economic growth, with things changing due to the COVID-19 shutdown of the economy, and what we anticipate may be a significant change in the economy going forward, we think that the issue around debt recovery, management and strategies are going to be even more important than it ever was in the area of aged care. And of course, the issue around debt recovery becomes all the more pronounced when we look at the prevalence of DAPs and we look at home care and the fees that are outstanding or recoverable in that context. It also becomes more pronounced given what is in effect the inability of providers to rely upon the security of tenure provisions to remove residents who haven't paid their debts within the allowed time. In our experience, reliance upon the security of tenure provisions is practically impossible, and so you must exhaust a number of the other pathways and avenues open to you to recover your money, which we will talk about today. And with that, I will introduce the speakers and the panelists answering the questions, and then I will leave it to them to provide more useful information. So our first speaker will be Alana Kasev. She is a Law Institute Wills and Estates accredited specialist. Ilana's well-rounded experience across all aspects of estate matters enables her to provide her clients with strategic and objective advice in relation to both estate planning and disputes. Whether it be creating an estate plan, resolving an estate dispute, or protecting those in vulnerable positions, Ilana can provide clear, straightforward advice by evaluating the circumstances and identifying practical solutions to their problems. Now, once Ilana has finished speaking, we'll then hand over to Gareth Kerr, who will then focus on the debt recovery strategies as well. Gareth primarily practices in the area of dispute resolution, risk management, and legislative compliance, including statutory interpretation. Gareth has experience working in the aged care sector, as well as previously managing a small business, and in that regard is very familiar with this area, although his business was successful as a result of those strategies that he employed. He helps aged care providers with their obligations under the Aged Care Act. He brings a commercial perspective and risk mitigation approach to his role as a lawyer. So they're the two speakers, and we also have joining us on the panel, Anita and Suzanne, who are going to assist with answering the questions. Anita's a principal in our aged care team, specialising in helping providers respond to and challenge decisions of the aged care regulators, as well as interpreting the legislation and the other duties that providers have towards residents. Suzanne is one of those commercial litigators who's very well familiar with this area. She's focused on retirement living, education, property, and building construction industries in the area of commercial litigation. She has a vast range of experience in disputes relevant to these industries, including with respect to leasing, adverse possession, breach of contract, defective building works, expert determinations, complaints, fee disputes, Australian consumer law, and defamation. She also has experience in insolvency matters and alternative dispute resolution, providing strategic advice with a focus on practical outcomes. So I think that between the four of them, we should be able to present some very useful information and certainly able to answer your questions. So with that, I shall now hand over to Ilana. Thanks, Ilana.
Thank you, Victor, for that introduction, and good morning to everyone. As Victor mentioned, my expertise is in estate planning, probate and administration and estate disputes, but I'm often engaged by our aged care team to assist in debt recovery when either dealing with a deceased estate or an attorney who is behaving badly. In recent matters referred to me from the aged care team, the matter is already at the stage where the resident has died, leaving behind unpaid aged care fees, and the provider is either uncertain who to pursue or how to pursue the debt. This can sometimes be caused by the fact that the person in charge of the estate, which is their executor under a will, might be different to the person, member or close friend acting as attorney for them, or even have an administrator appointed by a tribunal, such as the state trustees, who is responsible for their financial affairs. If the resident owes fees to a facility and they have an attorney or administrator managing their financial affairs, it may be possible that the attorney is not paying the fees because they're misusing the resident's funds, perhaps even for their own benefit. Whilst the resident is still the person liable for the fees at the end of the day, if they've got no funds left as a result of misconduct by the attorney, then there may be little merit in pursuing the resident, and further, there may be a risk that the problem perpetuates for the time that the resident remains with the provider. In such a situation, it could be possible to seek to have the attorney removed or even have them pay compensation to the resident through an application to one of the relevant state tribunals such as VCAT or NCAT. These tribunals can hear applications in relation to disputes arising from enduring powers of attorney. In Victoria, as an example, VCAT can make a number of orders, including removing attorneys and replacing them with an administrator, such as the state trustees, or an independent person such as an accountant or a lawyer, who will hopefully ensure that the financial management of the resident is properly conducted. They can appoint an administrator where a resident doesn't already have an attorney in place and no longer has capacity to make an enduring power of attorney, or they can make orders for the attorney to provide detailed accounts which get examined. And if any misuse of the resident's funds is identified during that audit, they can make compensation orders for the attorney to repay the resident, which will hopefully result in the provider being paid as well. These applications regarding powers of attorney can be made by the principal, the public advocate, nearest relatives of the resident, or any other person whom VCAT is satisfied has a special interest in the affairs of the principal resident. People who have a special interest could be a social worker, a close friend, or even an aged care provider. The provider could choose whether to make the application themselves, bearing in mind that they'll incur the legal fees which are not recoverable from the attorney or the resident, or they could request that a family member make the application themselves. The family member may obviously have concerns about the resident's financial well-being and would likely want to ensure that the attorney no longer acts. So too, the provider could make the application on the basis that the attorney is not acting in the best interests of the resident, which is putting the resident's accommodation in jeopardy. The collateral is that the provider ends up having their fees paid as well and looks good in the process by taking into account the resident's well-being. In other instances, a resident may not have a power of attorney in place, and we have seen providers apply to tribunals to appoint an administrator for a resident who has ceased paying fees on the basis that they are unable to manage their financial affairs as a result of losing capacity, which is proven to some extent by the mere fact that they're not paying their aged care fees. So, what can providers do to avoid these kinds of debt situations? Well, whilst the Aged Care Act authorises anyone to sign a resident agreement on behalf of a resident and is not limited to attorneys or the resident themselves, it would still be beneficial for providers on admission of residents to ask for a certified copy of the power of attorney and keep it on file, review the power of attorney and make sure who the attorney is. Is it one person acting? Is it two people? Are those two people acting jointly? Are they acting jointly and severally? Are there alternate attorneys? And make sure you've got all the contact details of all of these people. And then check when the power of attorney actually commences. For example, does it start immediately or does it start upon the resident losing capacity? And in which case the attorney only has authority to act when the resident loses capacity. And that's usually evidence through medical evidence. And the resident would only be, the power of attorney would then only be activated when the resident loses capacity. And next slide, please, Victor. So once a resident dies, the executor of their will or their administrator, who's the person most entitled to administer the estate when there is no will, is responsible for calling in assets of the estate and then attending to payments of the testamentary expenses and debts. In many cases, the executor will be required to apply for a grant of probate in order to have the authority to call in assets, particularly if the deceased owned real estate or has a RAD. The debts of the deceased at their date of death are included in the inventory of assets and liabilities, which is exhibited to the probate application. The executor has duties under both the will and the relevant state-based legislation relating to the administration of the estate to see to the due administration of the estate and to pay to attend to payment of the debts before distributing the estate to the beneficiaries. In some instances that I have seen relating to debts to providers, executors or administrators may think that they can avoid payment of the debt by not applying for a grant of probate or letters of administration. This makes it difficult for creditors to pursue the estate as there is no formally recognised executor or estate to pursue. However, executors who engage in this conduct often fail to realise that there are avenues for beneficiaries and creditors to compel them to apply for probate. For example, in Victoria, this is known as a Section 15 application, as it's made under Section 15 of the Administration and Probate Act. And a creditor can make this kind of application if there's a debt owing to them and it's been 6 or more weeks since the deceased person has died and the executor has not applied for probate. A creditor could also apply for letters of administration if there is no executor, and this is a non-litigious and fairly procedural process. At the moment, I'm assisting one provider with the Section 15 application on the basis that the daughter of the resident signed the resident agreement as the financial attorney. So we've written to the daughter asking her to confirm if she is the executor or if she is not, and putting her on notice that we're going to be making this claim. The creditor could also asked to seek orders to have themselves appointed as the administrator and then step in and administer the estate, or ask the court to appoint the state trustees. So just like when a resident is alive, a creditor could also apply to VCAT for compensation orders if they think that the attorney misused the resident's funds and there is no estate left as a result. In summary, the options that I've just mentioned should provide you with some understanding that there may be other means to pursue debt from a resident, both when they are alive and after their death, that do not fall within the typical debt collection process. And finally, I've also outlined some useful tips to bear in mind when admitting a new resident and ensuring good record keeping so that if debt recovery is necessitated, it is clear who to pursue.
Thanks, Alana. Very useful. And we've got some questions and comments that are coming in. And just a reminder, for any questions, put them in the Q&A panel. Our tech team can provide support to assist if there's an issue with getting them across to it. But Alana, just a couple of questions that are coming through. Once a resident has died, what are the ways that a provider can determine and find out who their executor is, the status of the probate application, and which law firm is acting, if any?
So there's a probate register online, and it's pretty easy to sort of search that register. I search it every day when dealing with my matters, and you can identify if probate has been applied for. You can see the date of death, and you can also see the lawyer's details, and then you've got a point of contact.
Okay, sounds exciting. Not many lawyers get to look at the online probate list every day. Could you just tell us, are there any time limitations for providers to seek orders at VCAT?
While someone is alive, there's no time restraints. So as soon as an issue has been identified, it would be good to sort of seize on that opportunity and make the application. But after death, there is a time limit of 6 months by which to seek compensation orders. So it's important to move pretty quickly after the person has died if you've identified that's the issue, that the attorney has been misappropriating funds.
Thanks, Alana. One of the questions that has come through would be good to understand when a resident deceases, what is the best option to identify the executor of the estate to recover monies? Would you suggest that that's looking at the online probate register for that information?
Well, that's a good source if they've gone through with the application and started that process. The difficulty can sometimes be if they haven't applied for probate yet and you're not actually sure who the executor is. So whether or not a copy of a will is something that might be on the provider's file, or some sort of details are provided, that will probably be your source. But I think another good reason for having the power of attorney on the file is that there's probably a good chance that the lawyer who prepared the power of attorney prepared a will, in which case you've got a good contact person to at least start off with. Okay,
thanks, Alana. And we've had a request, and I think this is a great idea. Is it possible for us to circulate to the participants the online website or link following the webinar?
I can get that, yes.
Excellent, we can do that. We're also going to be distributing the PowerPoint as well. Alana, time limits for making a Section 15 application. Are there any, and what's involved?
So you have to wait for 6 weeks to have lapsed following the date of death before you can commence that application. But I would not recommend doing it just after 6 weeks. I'd give it a bit more time, because the reality is it sometimes takes executors a little bit of time to collect information about the estate, get the death certificate. So it's pretty unlikely for someone to apply for probate within 6 weeks. The way I go about these things usually is starting off with a letter to the person who we think is the executor, putting them on notice of the claim, and letting them know that we'll be making that application, and identifying that a certain amount of time has lapsed and they haven't done anything before I'd be making that application. And the benefit of that kind of letter as well is that it could protect the person making the claim, or the creditor, for legal costs, because they've put them on notice and told them that they intend on making the claim. And then if nothing happens and they're forced to make the claim, at least they've got a good argument for costs.
Okay, thanks, Alana. And perhaps one more before we hand over to Gareth so he can get queued up. And in fact, the one that I was about to ask is similar. In fact, it's been answered. Will all state administrative tribunals do these processes or just VCAT? And Suzanne's helpfully answered that the state administrative tribunal in each state can hear these matters. And indeed, we've got somebody from New South Wales who also asked a similar one about whether the applications were able to be made against attorneys or executors in New South Wales via court or NCAT. And I think we've answered that again via Suzanne in relation to it, unless there's anything further, Alana, you wish to add to that, or any of the panellists?
I believe, all the tribunals are fairly similar in what they're able to do. There might be certain different time limits within each state and certain nuances, but generally speaking, these options would be available in most tribunals.
Okay, thanks, Alana. That was very helpful. Participants, feel free to continue to pose questions that relate to the content covered by Ilana. While I now hand over to Gareth to present in relation to estates, aged care and debt recovery. Thanks, Gareth.
Thanks, Victor. Good morning, everyone. I'd just like to make a personal welcome from myself to everyone attending this morning. As Victor's mentioned to you, my name is Gareth Kern. I'm an associate here at Russell Kennedy. I currently specialise in dispute resolution and commercial litigation. I'm also undertaking a Masters in Commercial Law with that focus. So building on what Ilana has said earlier this morning, I'm focusing today on strategies which can help prevent you getting to the debt recovery stage and which will put you in a stronger position in recovering the debt if you have to proceed down that path. Now, as we all know, the risk of unpaid debts is increasing due to the current COVID-19 pandemic and the resultant economic downturn, which is putting downward pressure on house sales. Less rents are coming in and residents don't have the cash to pay their accommodation fees. While proceeding to sending a letter of demand in and of itself isn't too costly, ultimately if the debt remains unpaid, then you will need to make a decision as to whether the potential recovery outweighs the cost of initiating legal proceedings to recover the debt. This generally comes down to two factors. Number one is whether your claim for the debt is good in law, and number two, whether the debtor who has the claim, who you have the claim against, has the capacity to pay. The purposes of the strategies which I'm about to share with you is to put you in the strongest position on both fronts, so that hopefully you won't need to proceed to legal proceedings to recover the debt, but that if you do, you know you've done everything in your power to try and ensure a successful outcome. So I'm just going to cover some debt prevention and mitigation strategies now, which I want to share with you all. The first strategy I have is it's a good idea to implement a clear debt recovery policy, which makes clear to staff the process for managing in the recovery of debts and any thresholds for when you should take action. So that might be either a time threshold, whether it's unpaid debts under over 30 days or 60 days, or whether it's a quantum aspect when they reach a certain amount. That's when you initiate the debt recovery process. The second tip I have is ascertain the capacity for the resident to pay before they enter the facility. Make the resident complete an asset declaration if possible. You should also conduct title searches and PPSR searches of the declared assets in order to inform yourself of any encumbrances against those assets, just so you know what the financial position of the resident coming to the facility is. The third strategy I have is ensure that the resident agreement is completed as thoroughly as possible. So make sure that all the contact details are included and that any payment arrangements are in place before commencement of the service before the resident moves in. It's important in this aspect to make sure that the resident agreement is properly executed, make sure that it is correctly signed. That is one of the most common mistakes I see, is that the agreements just haven't been signed properly. Secondly, another common mistake I see in resident agreements is that it's the next of kin which signs the agreement. The next of kin doesn't have really any authority to make any decisions. They may enter into a resident agreement on behalf of the residents, where the resident is unable to enter the agreement due to physical incapacity or mental impairment. But it is important, if that does, to make notes of reasons why the resident wasn't able to execute the agreement themselves. The only representative with a full legal authority to sign a resident agreement on behalf of a resident is a guardian with the power to make decisions about a person's accommodation and the services they receive. So it's a good idea to either get the guardian or the power of attorney with financial decision-making powers, or an administrator or financial manager to sign the agreement and be mentioned in the agreement so you know who they are. You should also obtain copies of any relevant power of attorneys or guardianship orders which have been made, if there are power of attorneys and guardians in place. If the agreement has been signed, you should keep a copy should be sent as soon as possible and evidence kept. So that is, send a copy to the power of attorney or the guardian. This will strengthen the argument that the persons have accepted the agreement should it be challenged at a later date. It should also include an estimate of fees in the agreement. I would presume the maximum if they don't have the Centrelink assessment. Otherwise, you can charge the maximum or partially defer it, even if you need to later refund it. The fourth strategy I have, apologies for 1 second, my computer's just, is entering into a deed of charge with the resident over any property that they might have, especially if it's been identified in the asset declaration. Once the deed is entered into, you should lodge a caveat over the property in order to secure the payment of the fees. And this will only apply to non-supported residents who have property. And this kind of security is not as important if the resident pays a RAD, as the unpaid amounts can be deducted when the resident leaves. However, this still means that you'll be carrying the debt of any unpaid daily fees until the resident leaves. The fifth strategy I have is you should also try and obtain a third-party guarantee. Normally that will be the next of kin or the power of attorney in order to guarantee the payment of the resident's fees by that third party. So this is an option for partially supported residents who don't have any property themselves. And I would also note that the amounts you're seeking to secure through the guarantee are amounts which the resident has deemed that, the government has deemed that the resident can pay. Therefore, there shouldn't be really any issue with enforcing of the guarantee, and you'd hope in those circumstances that you never have to proceed to actually call in upon the guarantee. The sixth strategy I have is that if a resident does not have a financial power of attorney, but wants someone to manage their payments to you, then you could also have the resident given irrevocable authority to a third party to pay funds it holds on behalf of the resident to you for payment of its fees. The seventh strategy I have is you can set up an automatic direct debit for the payment of fees and have that automated process ongoing. The eighth strategy I have is you should ensure that any difficulty in payment is identified as soon as possible so that the resident and yourself can manage and attempt to manage the situation before the debt accumulates. Keeping in regular contact with the resident about their finances will help to identify any issues that might arise at an early stage. And normally when the debt is at a smaller amount, it's more easily resolved than when it starts to accumulate over a period of months. The ninth strategy I have is you could offer a small percentage discount for the early prompt payment of fees, just to encourage the payment of fees in a timely manner. The 10th strategy I have is you should clearly state all the payment options and information on the invoices and in the resident agreement to make it easy for the resident to pay. The clearer these are, the easier it will be for the resident to not have the argument that they didn't know where to pay the money to, etc. The 11th strategy I have is you should ensure that all interactions with the resident and the representatives are properly documented in writing. So that is file notes, emails, letters, etc. It becomes important when you proceed down the debt recovery stage to have those records, just so everyone knows what the state of play was. And it's also important if the Aged Care Quality and Safety Commission gets involved, that you're able to show them the steps that you've taken. Now I'll move on to the debt recovery procedure. So this will depend on the policy that you have, and I'll just get Victor to move the slide one over. Perfect. So it will depend on the policy that you have in place, and generally we see is when debts are outstanding for 30 days or for 60 days. The first step of the debt recovery procedure is to just send a reminder to the resident or the relevant person who's paying the fees on their behalf, to invite them to contact you and just say, hey, look, we've got the overdue amount, and we I'd keep it pretty informal at the first stage. You don't want to start off adversarial. It normally means that you don't have as much success at the early point in time. The second step in the debt recovery procedure is if you don't receive a response to that initial contact, then I would call them or send them a reminder letter requesting payment by a certain date. And in that reminder letter, once again, just invite them to contact your relevant credit team and just have a discussion with you about the debt. Now, it does depend on the exact arrangement that you've entered into with the resident. So for example, if you know they've got a property that you have a charge and a caveat over, then you might be willing to negotiate the debt over a longer period of time because you've got that security. On the other hand, if you've got a pensioner who doesn't have any assets, you may need to move more quickly to ensure that they can pay the debt before it ends up becoming a lot more substantial in nature. We do know a few residents, we've got a few cases where they've just flat out stated that they're not paying, and it is difficult for the provider to do anything in those circumstances where they don't have that capacity. The third step of the debt recovery procedure is if no response is received to either of those attempts at contact, I would send a letter of demand by registered post or personally serve it upon the resident. The letter should state that a failure to make a payment or enter into a payment arrangement will result in the matter being referred to your solicitors, or if you have a debt collection agency, or it may result in the commencement of legal action. It should be noted in this letter that the debtor is jeopardising their accommodation. And also in this letter, you should make sure that it states that the debt is due and payable, and that it provides a reasonable time frame for the debt to be paid. The other thing I would mention in relation to the debtor jeopardising their accommodation is that under the user rights principles, as many of you may be aware, you can require a resident to leave the residential care services when the resident has not paid any agreed fee to yourselves within 42 days after the day when it was payable, since it's a reason that's within their control. This would include the responsibility to pay fees as specified in the agreement, or you could negotiate an alternative arrangement if there are any changes in their financial circumstances. You must not take any action, though, that makes the resident leave the residential care service or imply that the resident must leave the service before you have found suitable alternative accommodation or ensure that it is available. So this makes it difficult in practice if someone doesn't want to leave, and it's difficult to physically remove them from the premises, and we don't really see that occur. And there's potentially PR implications for kicking residents out of the facilities. And just in relation to home care in that regards, you can cease to provide home care to recipients if they've not met the responsibility to pay fees, but once again, there might be that PR aspect. The fourth step of the debt recovery procedure is that you refer now to the solicitors or the debt recovery collection agency. They will send a final letter of demand to the resident or the relevant person and state that if the payment is not made by a certain date, that you may then commence legal action against them and that they might be liable for your cost. And then the last and final step of the debt recovery procedure is instituting proceedings. Now, we know that sometimes a bit of a reluctance to institute proceedings, but that you do get a resolution, and generally we find they are fairly straightforward matters if you have all the relevant supporting documentation in place, that is the correctly signed resident agreement or the correctly executed charge guarantee. We don't normally see a negative press as a result of providers taking legal action, so there's not as much of that PR aspect. And the forms that you can take legal action through are generally the state-based tribunals. So in Victoria, that's VCAT. normally in relation to a small claim, or as Alana has pointed out earlier, if you want to have someone appointed as an administrator, for example, or a guardian, you can go through the magistrates court. Now, the magistrates court has jurisdiction up to the amount of $100,000. And this is typically where most debt recovery matters in the aged care space will fall. And if they don't file, if the debtor doesn't file a defence within 21 days of being served with the complaint, then you can apply for a default judgment to be entered against them. So once again, it's a bit more of a straightforward, lower cost jurisdiction. We also have the county court, which has unlimited jurisdiction to hear civil claims over $100,000. And this can be faster than the Supreme Court, since it has a good expedited list for straightforward matters like debt recovery. And then finally, we have the Supreme Court, which also has a jurisdiction of over $100,000 and limited jurisdiction to hear such matters. However, it is more costly and time-consuming to take a matter to the Supreme Court. The important thing in relation to all of these forums, no matter which one you take it through, is that the Limitation of Actions Act 1958 gives you 6 years to do it within. So just of that, I would hope that the debts don't lie outstanding for that amount of time in any event. So in summary, I hope that you found this presentation useful and you've gained some useful tips and strategies moving forward to manage the debt process, and if the debts do become due, that you have some insight into the steps that need to be taken to recover that debt. Thank you.
Thanks, Gareth. I think everyone's got a sufficient understanding and insight to know that the 11 or so strategies that you outlined with respect to recovering the debt are far more preferable to instituting proceedings. And as has been pointed out, which I absolutely agree, relying upon the security of tenure provisions is ultimately absolutely useless given the difficulty in doing it. And even if you do get to the stage of being able to provide a full alternative suitable accommodation, or indeed at the stage where you've got a judgment debt and perhaps seek an order in relation to removing someone, actually then physically removing them is almost next to impossible, or certainly challenging from a reputational point of view, if not from a legal point of view. We've had a number of questions that have come through, which I encourage the participants to have a look at in the answered section of the Q&A panel. Some recurring themes there as we come through, and I might just reiterate some of those for the benefit of the participants. But Gareth, before I do that, are you able to just let us know what is the most common issue that you've seen when seeking to recover a debt by approved providers?
So the most common issue that I've seen in my experience to date is mainly just not having properly executed agreements. It's unsure exactly who has the responsibility for the payment of the debt. So for example, if there is a power of attorney involved, they actually aren't listed in the resident agreement. So you try and contact the resident, they often don't know what you're actually really talking about. I'd make sure that the documents are correctly executed, as much detail is put into them as possible. All the relevant parties are listed in the agreement. The other difficulty that I come across with seeking the recovery of the debt is that some of these debts are just of too small amounts, so it doesn't really make it worth instituting proceedings to recover them. But even in those circumstances, as I previously mentioned, I would still proceed down the step to at least sending a letter of demand. Sometimes the letter itself can be a prompt for the payment of the debt.
Thanks, Gareth. One of the strategies that you mentioned, which we certainly fully endorse and include in our standard agreements, is obtaining guarantees. And I suppose really the question is, it's one thing to have the guarantee there, it's another thing to have an enforceable guarantee in place, signed or otherwise. What's your view in relation to the most common problems you've seen with regard to guarantees for aged care fees?
Yeah, so once again, it comes, I might sound like I'm repeating myself a little bit, but just have to make sure the guarantee is executed correctly and that the person that has entered the guarantee, while it's not necessarily they should obtain independent legal advice and state when they're signing the guarantee that they have had the opportunity to obtain that independent legal advice, and that will just kind of strengthen any counter arguments where they might say, I didn't know what I was signing, I was pressured into signing the guarantee, I was unduly influenced into signing the guarantee. If they have that essentially disclaimer saying they've had the opportunity to obtain the independent legal advice, it really helps counter those arguments. And they're kind of the common issues I see with guarantees. In saying that guarantees are enforceable, there's nothing preventing the enforceability in relation to the aged care sector. So I would definitely recommend that guarantees are entered into where possible.
Great, thanks, Gareth. I might just open it up to all panelists here to have an opportunity to answer a question that came in prior to the webinar. I'd like to thank Marion for sending it through. Marion asks a very pertinent question that I think actually has arisen in one of the questions posed during the webinar about how aged care providers, how can aged care providers avoid paying interest on the RADs when required to refund those deposits due to the death of the resident because there has been a significant delay in the approved provider being informed about who the funds are to be repaid to, and in particular the obtaining of probate, because of course there is a healthy interest rate that is payable by the approved providers that may be rather more attractive than receiving the money and putting it into the bank, particularly these days. So would anyone like to assist Marion with perhaps some strategies or tips for how an approved provider can manage this situation?
I'll answer that one. What we've seen a lot of providers opt for is having the executor of a will, if there is one, and even the beneficiaries in that will or some of the family members sign a deed of release and indemnity on the basis, and they get them to fill in a sort of questionnaire that accompanies that deed, and they ask a series of questions to evaluate the risks in possibly paying out the RAD before probate is granted on the basis of how sort of safe an estate is. So if they think it's a straightforward estate, perhaps no sort of risk of any challenges on the will because it's a family, not a blended family, the estate's left entirely to the spouse or just equally between all the children of the deceased resident, then they might elect to just pay it out without the production of a grant of probate on the basis that all those involved will sign a deed of release and indemnity, basically to protect the provider in the event that someone does come along and potentially makes a claim. One recommendation I've made is that if the payment is made, it's made by a cheque written out to the estate of, and potentially even that it's only paid into the trust account of a solicitor. So at least there's a bit of comfort there to know that the solicitor will pay it out to those who are actually entitled to it.
Thanks, Alana. Anybody else wish to add anything to that?
Yeah, Victor, I was just going to say the other strategy where you have quite a recalcitrant family in that scenario, and there are a few of them out there who are smart enough to realise that I'm actually getting a better interest rate than I would investing this money at the moment, so I'm just going to leave it with you. And we actually had a case a few years ago where it was 2 large bonds from a couple, and the interest was up around over 150,000 on each of them because it had been years and years. In that scenario, what we have found can be effective is you actually do a Section 15 application that Alana mentioned before. So you write to the estate, to the executor, and say, you're taking too long. The relevant Administration and Probate Act in Victoria and their equivalents in the other states says you're supposed to do this within 2 months. It's been 2 years or whatever it might have been. So if you don't apply for probate, we're going to take the matter to court and ask the court to appoint state trustees. And by the way, state trustees are going to take a chunk of the estate, so you might want to think about this. You don't necessarily get action straight away, but in most cases we found that actually does get things moving along, because they don't realise that they're vulnerable to that. And if you were to run that application, the good thing is you would probably get most of your legal costs covered, because you know there's money in the estate because you're sitting on a bond. So you'll actually be able to recover your legal costs as well. So that's quite an effective strategy in that case, in our experience.
Thanks, Anita. And of course, it's a happy circumstance if the approved provider at least has a lump sum that they can see to chase. Often the situations that we're dealing with, there is no happy circumstance of a lump sum that is sitting there. It's a case where the funds have been depleted, or indeed, for example, home care, where the fees are outstanding, in which case we need to look at the sorts of strategies that Gareth was outlining pre-death, perhaps, in relation to the recovery of the debt. Now, we've had a number of questions that came in with regard to the signing of the agreements. And of course, as has been pointed out, the obligation for approved providers is to provide the relevant agreements for the residents' clients to sign. The issue is, of course, that we can't make the residents sign it, but what we do rely upon there is the fact that providers should have taken steps to ensure that before entering into the facility or into the service, that the relevant agreements have been provided to the residents and clients, and explained to them, or provided in a manner where they can understand it. It's quite clear English is a second language and a barrier in terms of understanding the written document. The provision of those and then the entry into, for example, the facility might be taken to be evidence of acceptance of the terms of the agreement, notwithstanding that payment hasn't been made. We've also had some questions that relate to the capacity of people to enter into the agreement. As Gareth identified, the provision in the Aged Care Act that allows somebody to sign a resident agreement on behalf of somebody with a physical or mental impairment, slightly different change to the common law, but one which Justice Mortimer in a recent aged care case identified as being a convenient mechanism to deal with the practical reality that not everybody who enters into aged care has the capacity to be able to sign the resident agreement. And it's an easy mechanism to ensure that they sign the agreement as evidence so that they can enter into the facility. But I just wonder whether Suzanne, Anita, or Alana or Gareth, whether there was anything arising from the questions that have been asked that you wish to just alert participants to.
I think the only thing I would say is where someone hasn't signed the agreement and they've now entered into the facility, as Victor said, you can't literally force someone to sign something, but everything you can gather that shows and documents that they have received those papers, that they have then taken their place at the facility and they're receiving the services, will bolster your claim that they've accepted those terms and conditions. That can include sending self-serving letters that set out, we provided it to you on this date, we have asked you to sign it, you have not objected to it, you've moved in, and you're receiving the services. We take your conduct as acceptance. We do still require you to sign it. Please attend at the office to sign it, or something of that effect. But certainly a self-serving sentence that says we are taking your conduct as acceptance, because that way it's documented and it's up to the resident or their family really to come and then say, well, no, we don't accept them, and raise the issue, in which case at least you've got a line of communication opened.
Thanks, Suzanne. Very useful tips. Alana, without notice, but some interesting questions have come in dealing with executors and the identification of them. Stephen's asked, does a provider have recourse if a solicitor advises that Section 99 of the Probate and Admin Act applies, and thus probate will not be forwarded by the executor for 6 months? What's your view about that situation?
If probate has not been forwarded by 6 months, I'm not too sure what.
And thus probate will not be forwarded by the executor for 6 months?
That's an interesting question. It's probably something I'd have to look at a bit after. The 6 month period usually relates to claims against the estate. So it might be something I'd have to speak with Stephen about a bit more in detail to find out what he means exactly.
So if what we're talking about there is that they're suggesting the 6-month claim period should expire before probate is obtained or forwarded, your suggestion there is that that would not be an appropriate reason why we shouldn't pursue the matter.
The 6-month claim window for challenging an estate, that ends 6 months after probate is actually granted.
Yeah,
So
so that doesn't become a reason why we shouldn't pursue the issue of probate to begin with, because exactly probate that we need to protect
to make a claim.
or
That's right. That's right.
Take the claim. So
That's right.
Stephen, I hope that answers your question. If it doesn't, feel free to provide either further information in the Q&A or directly to Alana following this. Ronnie has asked, where executors are parking a RAD with providers from an interest and they have probate but do not provide it to the provider, what can be done to pay the RAD to the estate? I think we covered that earlier on. Would that be, Alana, a situation where Section 15 application ought be made?
Yeah, potentially. Yeah.
To change the executor, potentially. If they won't give details of a bank account, or if there's a solicitor acting, you can send it to the solicitor's trust account made out to the estate.
Yep. I'm sorry, I wasn't listening properly, but so we could try and challenge the that. So Mr. Edwards has asked, how do we identify the executor if probate hasn't been granted? Again, I think, Ilana, maybe you could just reiterate what you said earlier about that.
Yeah, that can be a bit tricky. Obviously, you can either check online. As I mentioned earlier, one of the reasons why I think it's good to have the power of attorney in the file is because there's a good bet that the lawyer who prepared that power of attorney prepared the will. So you could contact the lawyer who prepared the documents and ask, and you'd have standing as a creditor to see the will if the resident has died. So at least you'd know who the executor is and you'd be able to pinpoint who it is. If that doesn't prove any luck, I've sometimes done title searches on the resident's property if they do have property to see who was the conveyancer or the lawyer who did the transfer of land. That's another avenue to contact that lawyer, find out if they're holding a will. But beyond that can be a little bit tricky, but it might be worth even writing a letter to the next of kin saying, are you the executor of the will? Please provide us with a copy. And if they just, bury their heads in the sand and don't reply, potentially you could say, well, we're going to assume that that's the case if you don't tell us otherwise, and we're going to make the Section 15 application on that basis. And we might seek to have orders to have the state trustees appointed, as Anita mentioned before, and hopefully that just makes them realise they can't bury their heads in the sand and think this will all go away.
And I think any time that you are indicating to people that you may have to go and seek the assistance of state trustees, it's always useful to mention that state trustees do charge fees, because obviously a lot of people do these sorts of things to try and park money to earn interest, etc. They need to understand that if you are going to go and take a step to engage or to have an independent person engaged to administer, that person can charge fees.
Thanks, Suzanne and Alana. This one, Gareth, might be for you. Neil's asked if there's a guarantor or caveat clause in the residential agreement which is unsigned, can the giving of the guarantee or caveat be implied such that it is enforceable?
No, a charge on land must be signed.
Yeah, I was just about to say that. Yes, I would say you've got to sign it. I wouldn't be comfortable. I don't think there'd be a solicitor be comfortable lodging a caveat in those circumstances. Yeah.
Neil, the answer to that quite clearly with respect to the caveat is no. It needs to be signed for it to be enforceable, and for all intents and purposes, we'd say the same with respect to the guarantee in that without anything else. You need to be very careful about caveats, because if they are lodged without basis, then you can actually be ordered to pay money if someone takes issue with you. So
if you are looking to put a caveat over someone's property, then please do come and ask us about it first, particularly if you've got a caveat clause and you're wondering whether you're allowed to act on it.
Thanks, Suzanne. Okay, we've got a couple more questions, and then we're going to hand over for a very quick wind up by the speakers about key takeaways. So we've got one question that has come in. What would you suggest where probate's been granted but the executor refuses to administer the estate and continues living in the estate property? I think we have dealt with that in terms of the response there about changing the executor. Is there anything else to add to that? No?
Depending on the time lapsed, you could ask the executor to provide an administration account on oath. You could get the registrar of probate to demand that, and then that can sort of put all the cards on the table to show what's happening with the administration of the estate. And yeah, from there, that could lead on to potentially an executor removal application or various other applications.
Sure, thanks, Alana. And questions being asked about the challenges. What is someone challenges a payment of a rate prior to the probate that has not executed a deed of release? Risky approach? Hands up all of those that would say yes. So I think what we've got there is a typical situation where we don't have probate granted, so we haven't got someone with clear legal authority to receive the money from the estate. And that poses significant risk if indeed it's paid to the wrong person. And then the legally entitled person, the executor, comes chasing you for the payment of the money. So definitely a risky approach. Okay, well, perhaps with that, what we might do, there's one question there that I'm sure somebody could answer directly, but we might move to wrapping up the webinar now. So perhaps if I could just hand it over to our presenters to discuss their key takeaways and from this webinar.
Well, yeah, as I've said, I think, and Gareth's touched on it as well, documenting your files is key, having powers of attorney in the file, understanding who it is who's legally responsible for managing a resident's affairs are, and also that just because someone's died doesn't mean that the debt dies with them. So if executors are taking that approach, there are possible actions you can take against them, such as the Section 15 application.
Thank you. Gareth, Anita, Suzanne, anything you wish to add to that?
Just echoing what Alana just said, the main takeaways I would have is just make sure the documents are executed correctly, and also that you have a policy in place which essentially outlines the steps that your organisation is going to take to try and recover debt, so everyone's on the same page and you know what the relevant triggers are when you move to different stages of the debt recovery process.
Thanks, Gareth. Well, with that, I might bring this to a conclusion. I'd like to thank Alana and Gareth for their very interesting and insightful presentation, and Anita and Suzanne for assisting with answering questions both in the Q&A and live. I think we've learnt a lot, and there's a lot of very useful information, but as I said, it's by way of general commentary, and I would invite participants who need assistance with any of the aspects that we've spoken about today to contact us directly for legal advice. We will be sending through a copy of the webinar and the slides for your general information in relation to it. And if you do have any remaining questions, then please send them through. I see we have got a couple of questions that we will get to and keep our 100% answer rate intact for the webinar, so we will certainly do that. Please complete the feedback survey when it comes through so that we can feed this in. And we look forward to seeing you again in the next webinar. So thanks for joining us today, and have a good day and enjoy the weekend. Goodbye.
Thank you.